Okay, for our next topic, the moderator of the topic is going to be Bill Banks, who you have already met. Let me just very briefly summarize his background. Professor Banks is the Laura J. and L. Douglas Meredith Professor of Law at Syracuse University College of Law, where he became the founding director of the Institute for National Security and Counterterrorism at Syracuse University in 2003. He co-wrote the leading text in the field, National Security Law, first published in 1990. Bill and his co-authors published Counterterrorism Law in 2007 to help define this emerging law. Joining him on the panel this afternoon are first Mary Ellen O'Connell. She is the Robert and Marion Short Professor of Law at the University of Notre Dame Law School. Before joining Notre Dame, where she teaches contracts and international law, Professor O'Connell was the William B. Saxby Professor of Law at the Ohio State University Moritz College of Law. Her research focuses on international regulation of force and conflict, as well as peaceful resolution of disputes before they escalate to armed conflict. George Fletcher, most of you already met this morning, and he has been introduced. One aspect of his background that Bill Merkel failed to identify in his introduction is that Professor Fletcher was very helpful in our recruitment of Bill Merkel to our faculty, and for that we are certainly grateful. George Fletcher is also the Cardozo Professor of Jurisprudence, Columbia Law School, published hundreds of scholarly articles, 11 books. In 2004, he was elected to the American Academy of Arts and Sciences. Noah Weisbrod is the Visiting Assistant Professor of Law at Duke University School of Law. Prior to assuming his current post at Duke Law School, he was law clerk to Chief Prosecutor Luis Moreno Ocampo at the International Criminal Court in The Hague. Professor Weisbrod is currently a delegate to the Special Working Group on the Crime of Aggression established by the Assembly of States Parties to the International Criminal Court. And with that, I'm going to turn it over to Bill Banks.
Just a moment here to reacquaint myself with the technology. It's always the case that the panel immediately after lunch faces a tremendous challenge in keeping all of you awake, and it's yet another testament to Dean Romig and the organizers here of putting the very best panel immediately after lunch. I assure you, you won't have any problem here staying awake this afternoon. I'm going to be very brief. The use of military force was not an inevitable government response to terrorism. So we're here in large part to talk about the options. The policy choices other than the use of military force were available to us, of course, after September 11th, when Congress authorized armed force in response to those attacks. The panelists this afternoon will discuss whether the use of military force is the appropriate response to terrorism, how a war against non-state terrorists differs from a war against a nation-state, when, if ever, is preemptive use of force permitted or warranted, and in the current context is the counterterrorism effort that the United States has been engaged in since September the 11th, a war or an armed conflict or something else. If terrorists are the enemy, are captured suspected terrorists detainees? Are they enemy combatants? Are they prisoners of war? Are they criminals who should be charged in the criminal justice system? We'll begin with comments from each of our panelists going across the table here, Professor O'Connell, Professor Fletcher, and Professor Weisbrod. Each will take about 10 minutes. There'll be a time perhaps for me to interject a question or two then, and then we'll have some time for you to ask questions of them. Professor O'Connell.
Thank you, Bill. I just wanted to add one brief point to my bio that was set out very nicely, because I think it bears supporting why somebody like me has the right to even talk about law on the use of force. I don't think it's something that we just do lightly. But in my case, I did teach international law on the use of force for the Department of Defense for 3 years. I was a Title X professional military educator, but that's not really why I think I can talk about these topics. It was more because I served my country as an Army wife. My husband is a highly decorated combat veteran and former interrogator, and it's from him that I think I came to understand how very important this law is that we're discussing today. And I'd like to really associate myself with David Graham's opening remarks. I really do share the perspective that he began with. I do, however, want to begin with a more abstract and general principle about our topic. I want to begin with first principles, or a first principle, perhaps the most important foundational principle that we have in the law, all law, not just international law. And that is that our conduct is assessed under the law in place at the time of that conduct. Of course, that is a principle that incorporates just the most basic and fundamental notions of fairness. But it also incorporates one of the features of law that keeps law legitimate, appropriate, reflecting wisdom and principle. Much law is developed slowly over time, reflecting our best ideas, our developing understanding about how best to respond to particular human problems, our higher norms and aspirations. This is certainly true, and I think obviously true with regard to the common law, plainly developed slowly over time, but also customary international law. But I think the same can be said with regard to treaties and legislation. They come through a process that takes time, requires negotiation, development of facts, understanding. Law is generally not made in times of stress and chaos, in an emergency, and that's for good reason. That's what happened in this country on 9/11. We made law, some of our leadership decided to, on that day, tear away the existing law and suddenly and almost overnight make new law. And I think we've seen the incredible disadvantages of making law in that way and the cost to our country of having done so. The President heard from these legal advisors that he should do away with the Geneva Conventions. Certainly most of customary international law, he shouldn't consider that it binds on him. He's the President, he can break the law. And he probably didn't even hear anything about the general principles of international law. We now see what can happen when settled law is thrown off precipitously. Guantanamo Bay, Abu Ghraib, Afghanistan after 7.5 years of fighting, no end in sight, Iraq, Somalia, secret prisons, torture, lost standing in the world, and going forward, weakened norms against the use of force. Weakened norms that do not put us in the position to challenge countries like Iran, China, Sudan, Russia, which we would dearly like to do. We'd like to remind them of their binding obligations under treaties like the Non-Proliferation Convention, under the UN Charter not to invade other countries. This is the legacy that we are reaping after 8 years.